Committed to Miramar is a weekly radio talk show hosted by Commissioner Darlene Riggs and longtime Miramarian Sherry Abden. The purpose of Committed to Miramar is to keep you in tune with what's happening in the beautiful city of Miramar, covering topics from healthcare, entertainment, employment, to education, politics, and much more. Tune in every Wednesday at 5 p.m. to Radio Unilatina USA. Use hashtag Committed to Miramar.
Hello, Miramarians. I'm Commissioner Darlene Riggs, Commissioner of the beautiful, beautiful city of Miramar, and I'm here with
Sherry Abden, her co-host. Hi, Miramar.
Miramarians, we are very excited for another great show. Popular demands, I would say. I've had quite a few questions in reference to wills. I don't know why I attract those questions. Folks have a lot of questions about living wills, maybe because of the nursing component. I'm not sure.
And the fact that you're a commissioner and you know everything.
And it's so funny because I'm thinking, oh, I don't know the answer to that. I need to get you an expert. And guess what, Miramarians? We have an expert here with us. And, you know, I'm so glad that I have the opportunity to have the one and only Miss Latrice K. McPhee, who is going to educate us all about wills, right?
I'm going to do my best. I'm not an expert, but I will try to give you the best answers I possibly can give you.
Excellent. We are first, before we get into the, meat and that chunky stuff here with all that lovely information that we're going to give to our Miramarians, which is extremely important. I want to give you an opportunity to introduce yourself, tell us a little bit about you, and then we'll get into the importance of having a will and the logistics and, some things that we probably never thought of. And then we're going to realize, okay, yeah, I better get up and get this done. So do us a favor, please introduce yourself to our Miramarians. Let them know who you are, where you are, what you're doing.
No problem. As Commissioner Riggs just stated, my name is Latrice K. McPhee, and I am a practicing attorney here in the beautiful city of Miramar. My firm covers areas from Miami to Broward County and also to Palm Beach County. Mm-hmm. The areas that I practice include sports and entertainment, family criminal, and of course, wills and estate planning.
Nice. We may have to have a show on, sports.
Okay. Well,
that's got to be interesting.
Absolutely fabulous. I actually have a phone conference this evening with a gentleman who happens to play professionally at the moment. So
you probably have some stories with those, huh? Yeah. Okay, that's a whole nother hour.
That's a whole lot of fun as well.
Oh my goodness. So let's start. First of all, I cannot even begin to tell you how important it is to have a will, because as a nurse, first of all, we're obligated. For example, you get into the hospital for whatever reason, you have to be admitted. One of the questions that we must ask you is if you have, a living will, do you have a surrogate? So we're mandated to do that. And we're even mandated, if you don't have one and would like to start one, we have to provide you with the information to start one. So, and I've seen so many cases where if folks had something in place, my goodness, how easier would things be? And you've seen in the media where there's some high profile cases where if there was a will, things, it wouldn't have gotten so complicated, who, what, where, when, who receives what. So it's extremely important. It's not something you should wait till last minute to do. And then plus, sometimes if you wait and you're not mentally together, it's too late.
Yeah, exactly.
And while you're mentally together, awake, alert, and oriented times 3, is a good time to get this going.
Absolutely.
So I cannot even tell you, Miramarians, if you're listening, please get some pen and paper so you can jot some things down. You may have some of the situations we're even going to talk about, some of the examples we're going to talk about. So let's start from the very beginning, from the bottom. What is a will?
A will is nothing more than a legal document wherein you get to decide the disposition of your personal property and your assets. There are requirements to having a will, but in terms of what it actually is, that's pretty much it. It's just a legal document where you decide while you are alive who gets what, when, how, and so forth.
And is that everything? Like undergarments and all?
Well, if you have a $10,000 pair of undies, I think you would want to decide
your secret bra.
Yes, the ones that the angels wear to walk in the runway. You may want to
really want to decide who gets
exactly. So that could be a possibility.
You can really name anything on your will,
if it's of value. That's typically what most people name, those things that are of value that they need.
Well, what may be valuable to me may not be valuable to someone else, but hey, if the undergarments are valuable, they're valuable. I'd like to determine who gets.
That is correct.
Now, is it only an attorney that can do a will?
I would suggest that an attorney prepare a will, simply because, number one, you want to make sure all of the considerations and everything that you want and how you want it to be disposed of, you will want to make sure that the proper language is used, and someone with some legal knowledge would be able to provide that information accordingly, versus you trying to do it yourself. So, being that I am an attorney, I'm not going to tell you don't go to an attorney, but I'm not going to tell you have to go to an attorney. But I would recommend. I do not believe in practicing or suggesting self-representation. They have a saying about people who represent themselves. Well, at least lawyers
have a fool for a client. Lovely.
Yes.
Before we continue, knowing the little bit of legal stuff that I do know, I need to read this disclaimer. So the topics and information provided are for educational and or informational purposes only. It is not intended to serve as legal advice, and there is no attorney-client relationship here. For specific advice regarding your personal experience, you should contact counsel of your choice. So are we now legally good?
I think that would do it. I don't want any problems from anyone in particular. So I think that we're good.
How funny. This is the the era that we're in. Remember forever ago, at least in movies, where your word just used to be your word. Right. You don't need it witnessed, notarized, laminated, and not anymore. We can't go by folks' words anymore. I need it in writing. I need it witnessed. I need it notarized. I need it. Yeah. How crazy, right?
That is true.
It's bad because I don't think that way. Even though we're in the era that we're in. If I tell somebody something, I mean it. That's it. There's no need to.
Because your word has value, and not everyone is like that.
Correct. Now, how long ago was that you were able to do that, and you didn't have to worry about getting anything in writing?
Oh no, I do now. How funny. Okay, so why is it important from your perspective? I just told our Miramarians why it's important, to have a will. But from your legal perspective, why is it important?
Well, first of all, if you have a will, that means that I don't have to go to court as much. I don't have to argue as much. Because in reality, you want to make the decisions as to who gets what. If a person passes and there is no will, that person would be, or that estate would be deemed intestate. Mm-hmm. By that, the court will then follow the rules and the statutes in terms of how your property would be distributed among the beneficiaries. You don't want that to happen. You want to have complete control over who gets what, when, and so forth. You do not want them saying, okay, the child or someone in your family who is not in your good graces at the time of one's demise. You don't have any kids, but a sibling. If you pass and you don't have a will, 9 times out of 10, depending on other applicable laws or what have you, that sibling may likely inherit something from your estate. So you want to be in control and make those decisions versus having the state to come in and control who gets what and make those decisions. I'm sure you've heard of the situation with a recent celebrity who did not have a will. I'm sure you've heard. I don't want to call any names. But, some people have often said, well, I don't necessarily need a will. I don't have much. If you have $50, you still perhaps may want to consider having a will because you don't know what is out there in terms of, lost money. You could have inherited something that you may not have known about it. And you would still prevent the state from coming in, making the decision pursuant to the statute as to how your assets would be divided.
And anyone that has loved ones should really think about this and consider this. The other thing that comes to mind is next of kin. So in the sense of next of kin, first of all, if you're married, that's automatically your next of kin, right? Is that the rule?
I believe it is.
Unless you, of course, name somebody, which is what we're talking about. But if you have no living will, no healthcare surrogate, nothing, automatically it's your spouse.
If you have a spouse, yes.
Even if you're separated.
If you are still legally married. As a matter of fact.
That's who gets everything.
Exactly. And people don't really understand that concept. Oh, I have been separated from Johnny for 50 years. I could care less if you've been separated from Johnny for 500 years. Johnny has the right to come in, intervene, and basically take over and disposing, calling the shots, so to speak, for lack of a better word, to disposing or distributing your estate unless he waives the right to do so. Johnny would be the one who would come in, more likely than not. He would be the administrator of your estate.
And that has to be done legally as well, right? Him waiving or she waiving their rights.
That's not something that you can just throw away. You have to follow the formal procedures that are in place for that to happen. Now, there are some situations where a person, even if you choose to have a particular person serve as your personal representative in a will, it may not necessarily happen because Florida law requires that there are certain criteria that one must have, or there's a certain criteria that will prevent or allow someone to be able to administer your estate. For example, if one is a convicted felon, it's not likely
Okay.
that you would be able to administer an estate. And now I can say from my own personal experiences between Miami-Dade and Broward County, there's something called a criminal affidavit that you need to file once an estate is open through probate, where you have to attest to the fact that you have no criminal history. And there are some other questions on it because it's important for the courts to know who is trying to administer an estate.
So what happens if you name someone as your surrogate that is a criminal?
Okay.
Does that
Would-
bypass?
Surrogate in what respect?
So-
Because we're talking about wills, so I don't know if you're talking about something else.
I'm talking about like, okay, I'm thinking health, the nursing in me.
Okay.
I'm thinking about healthcare. So for a will, can you do this? Can you name anyone, even if they're a criminal, on a living will as to who?
you can name them, but if the court is aware that the person has,
They can override that? That sucks.
thus the term court.
Damn.
How young of age does a person need to, that you recommend them to have a will? Is there an age? Do they have to wait for 18?
Well, in the state of Florida, of course, that there's a legal age requirement for you to be able to sign off on any legal document, and that rule still applies. You cannot, someone at the age of 15 cannot sign a legal document, so you still would have to follow those laws that are in place in terms of who can sign and who can execute certain documents. Now, if you have a power of attorney, which gives you that ability to do so in certain instances, then you can sign on behalf of. But there are some other considerations that you need to keep in mind when you're talking about having a power of attorney and what you can do with it, because that may limit the person ability who has given you.
So you have to be legally an adult.
I would say so, yes.
So my 14-year-old can't.
Absolutely.
Like, mom. So in the sense of who should have a will, anybody who's legally an adult should.
I would say anyone who has anything, even a dollar.
Valuable.
I mean, because you don't know what life has to offer. So I would suggest that you have a will. Definitely, it's important to have a will because at the end of the day, you want to be in control of what you have, who gets what, and you don't want anyone stepping in, taking over, trying to tell you what you didn't want to happen. You don't want them to decide that is what's going to happen.
Before we go on a break, so we were talking about the next of kin. So if you're married, that's automatically who that is. But what happens if you're not married? Is it your parents who would be the person who handles
not necessarily, because you could have children. You don't have to be
your oldest
married.
child, right?
You don't have to. You don't necessarily have to be married. You could have your kids. There could be your parents. So each person's circumstances and their situation, it varies. So, for example, Bobby could be married to Brenda, and they may have 10 children. Something happens to Bobby, then Brenda, in that instance, is his next of kin, followed in succession by
the oldest
their
child.
children.
Okay.
So,
but it's not the oldest child. It would be like a.
Well, I don't really quite understand what you're saying. Who's the next of kin? It would be the wife, and then if something happens to the wife,
then the children.
And
I always, for some reason, thought it was the oldest child. Oh, because there's some fight. Can you imagine? Yeah. One child wants it this way, the other child wants this, or this one child wants that. Mom said I could have had
as a
this.
parent, you know your kids and their
Exactly.
personality. So you may not have Bobby because he's going to spend everything the wrong way. So you might jump down
it's
the
not
line.
necessarily the
There
oldest
you
child.
go.
That's why parents
Irresponsible Bobby.
Exactly. That's why parents choose who they want. They may not want their husband to be their personal representative. They may want somebody
Some folks find that out after, somebody's gone, which really is, I mean, I've had cases in the hospital where that happens, where after somebody passes away, we find out that the spouse was not.
But I will say this in terms
very
of
uncomfortable moment.
In terms of how things are actually done, typically the spouse, if you are a married person, the spouse is the person that the courts would generally look to as being the personal representative of your estate. They can waive that right.
I know someone recently who did pass away, and the wife found that she didn't inherit everything, that the husband left some things for his sister. So she was very upset that she wasn't in control of everything, that part of it went to the sister, but she didn't find out until he passed away. And it wasn't pretty.
I'm sure she could challenge.
Was there a will? That's the first thing.
Right, there was. And he named it beautifully, who, what, where,
He decided who was the personal representative?
She did not know.
So she wasn't named as a personal representative?
No, apparently, from what I was told, which I try to stay out of the whole drama, he outlined everything, and she was not the one in charge, but she did get, I believe she ended up with the life insurance, but then the sister ended up with everything else, the investments and all of that I guess only he...
Well, one thing you have to understand now you're onto a different area, so to speak, but when you're talking about life insurance and other investments in certain types of accounts, those things pass outside of a will. You don't necessarily need a will for those things. Okay. The only time a will typically come into play is if you don't name beneficiaries. Now, when you go to take out open up a bank account, they ask you who the beneficiaries are. So upon a person's demise, all you would typically need, and I'm saying typically because life changes, so many things happen, and there are so many nuances and loopholes, but typically you would need to obtain a certified copy of the death certificate. You take it to that institution and you can get everything that's in there. If you are listed as a beneficiary, if you're listed as being a joint owner of an account, you don't need anything. You're a joint owner on the account.
Could you be I'm sorry for interrupt. Could you be a beneficiary without knowing? Can somebody put you?
That's why I said it's very important to have a will, because you may have received some money through that treasury thing. I don't know.
And not even know.
And then your relatives find out that you are the recipient of $20 million. And you didn't have a will, so now it has to be divided the way the state says. But if you had a will, it'll be divided. So you see, it's possible you can be the recipient of, because sometimes they may not be able to locate you. So they can't locate you. Then after a certain period of time, that money is going to automatically go to the state. And then it'll just sit there until I don't know when, but
it's easy to locate me. So you don't need the social or anything like that. I'll be a beneficiary. Okay. We are so past.
We will need the social. That'll make life easier.
Oh, man. We are so past a break time, but this is so interesting. When we come back, we have so many challenging questions. I hope you're ready for it. I have some complicated situations that I've known about, so I have to ask you, because you never know which Miramarians listening
I can answer
may have these situations. But Miramarians, you're listening to Committed to Miramar. I'm Commissioner Darlene Riggs. We'll be right back.
Unilatina International College with campus in Miramar, Florida is a boutique college with focus on entrepreneurship. UIC offers associate and bachelor degree programs in business, tourism, and communications and media. Associate degree students develop their business plan while studying at UIC. Dream, learn, and grow. Join now our business incubator. Learn more at unilatina.edu or call 954-607-4344. Unilatina International College with campus in Miramar, Florida is a boutique college with an applied, cutting-edge holistic education model. Business, tourism, and communication students not only develop their field intellectual skills, but are also empowered to become holistic professionals and human beings through yoga, self-empowerment, holistic human development courses, and more. Sign up to become a holistic professional at unilatina.edu or call 954-607-4344.
Committed to Miramar, committed to our community. It's right here in Miramar.
Hello, Miramarians. Welcome back. And we are here with the one and only Miss Latrice K. McPhee.
Hello, Miramar.
You know something, before we go further into educating the community on wills, I want to mention a nice charity. Okay. And I want to give folks some information on how to get a hold of you through Anais Charity, because through your charity, you do so many events, including the 100 Will. And you have a very important seminar coming up, a family law seminar. So I want give folks some information about that, and also Anais Charity and the phone number and how to get a hold of you, and the save the date. Very important. And then we'll continue with educating the community on living wills.
Simple wills.
Oh, simple
wills.
Complicated wills. All kinds of wills.
Okay. Anais Charities is a 501c3 not-for-profit tax-exempt organization here in the beautiful city of Miramar. Because of my daughter, Kyra Williams, because of her desire to start a not-for-profit, we have engaged upon so many different things. One being the presentation of 100 Wills with Commissioner Darlene Riggs. She has been our sponsor for 2 years, and she supported us. In addition to 100 Wills, we have other activities and events and initiatives, including Protecting Our Pals, Beats, which is a symposium for students, minorities who are interested in pursuing careers in STEM fields, science, technology, engineering, architecture, and math. And we also have Comforting the Homeless, where we actually go out into the community, different communities. It doesn't have to be Broward or Miramar. It could be wherever, Miami-Dade, Broward, Palm Beach County. And we actually provide blankets and water and those things that are legally permissible for us to provide to those individuals who are less fortunate. So we try to do quite a few different things. And I know I'm missing something, Protecting Our Pals, where we actually raise money for animals who have been lost, neglected, or abandoned.
Oh, wow.
And I think that is so important, because here lately you've been seeing so many times on TV that a dog was abused, it was left here, and it's really heartbreaking to see these poor defenseless animals not be able to, do anything for themselves. So,
Well,
How amazing to have a law firm give animals rights.
well, it's not the firm, it's the charity.
Well, the charity.
See, we separate the
corrected.
two. We don't want any problems with clients.
funny.
So
She gives free legal advice.
Exactly. That's exactly right. So the charity does it. But of course, the firm is very involved, and my daughter works with, as a matter of fact, her advisors and her counselors are pretty much all attorneys. I think I just happen to be an attorney who's
lucky you. Lucky young lady. You have a save the date for the family law seminar. When is this taking place?
It is February, I believe.
23rd.
Thank you. February 23rd, 2018, Saturday at 9:00 a.m. We are going to be talking about family law. There are so many different things that people don't understand, in particular, young men. We really want you to come out, because there are so misconceptions, especially when you have a child and you're not wed. I hear young men say often, "Oh, I signed the birth certificate." I will pose you with one question. I'm not even going to answer it. But my question to you is, did you really sign the birth certificate? We'll talk about that more in depth when you come. And if you want to come and be a part of this particular event, it's called, what is it called?
Family law seminar?
No, that's not what it's called.
No.
We talked about, what is it called? Okay.
We talk about so many events.
No, the title of it, and you like the title of it. I don't even remember, and that's it.
For the
family law.
For the seminar?
Oh, it's a matter of family law. It's a matter of family law. That's it.
Oh, the title of the seminar. Okay, gotcha.
And we're going to be talking about so many different things.
You have too much going on. I thought I had a lot going on.
Oh, no. I
want to give them the phone number before we move forward. 954-228-9415. One more time, 954-228-9415 for more information.
And if you want to email us, you can email us at, I believe it's info@AnaisCharities.org. And that would be info, INFO, at Anais, which is spelled ANAIYS, Charities, which is CHARITIES
Awesome.
I think I got it right.
Before we continue, in case folks are just turning in, I want to remind them that the topics and information provided are for educational and informational purposes only. It is not intended to serve as legal advice, and there is no attorney-client relationship.
Absolutely not.
Specific advice, they must reach out to their personal counsel of choice.
Absolutely.
Awesome. Okay, perfect. So we're covered legally. So let's pick up where we left off. Now, there are so often we're talking about, how important it is to have a will, but what happens when there is no will? So, God forbid somebody passes away, there's zero will, and if I understand this correctly, the state gets involved.
Well, that person would be considered to have died intestate, which means there is no will. And being that there is no will at that particular time, the disposition of their personal property and or their assets or what have you, it will be disposed of according to the statutes and the procedures set forth by the state.
Okay, so that's just a recap pretty much of what we talked about earlier. So now, let's say they did do the right thing and they did obtain a will that highlights beautifully who, what, where, when, right?
And they would then be considered testate, because testate means that the person
has a will. So now let's start from the beginning. So I decide I want to get a will. I'm married.
Are you coming to 100 wills to get it done?
Yes, ma'am.
Okay.
So now, does my husband need to come with me if I want to do a will?
Does your husband need to come? Well, let me just say this.
I love you, honey, but it's just a question. Some folks may want to get a will and not bring the spouse.
Well, that's true. Now, personally, professionally, it's up to them. I mean, I've had situations where the husband and wife want to come. I don't necessarily like that option, but it's possible. But your husband doesn't have to come with you, because there may be something that you don't want your husband to know about. So keep in mind that, it keeps the attorney out of a compromising situation. If you have let me change that a little bit. If you come together, then that means you have everything on an open book.
Right.
Open book. Everybody knows everything. But if
Which
you come separately, right? But there are some things that you may not want your spouse to know. You've had $100 million hidden.
Oh,
before you got married.
Handle everything. Where do I sign? Like, I don't really so much get involved.
You may not want him to know about that. So, should you have some privacy, confidentiality? I mean, I can't say it, but I will tell you what I would do. I would go by myself. That's what I would do. That's just me. I'm just saying. I'm being honest.
And they have to be witnessed, right?
Yes, they do. Florida requires that there are 2 witnesses.
2, wow.
All right, 2 witnesses. And it's suggested that it be self-proving, wherein the testator and the witnesses all sign in each other's presence. And that's what makes it self-proven. Now, even if the will is not self-proven, it doesn't mean that it's invalid. But basically, the witnesses would have to be called into court, and they would have to authenticate the will.
So then it doesn't necessarily have to be people you know.
I suggest whenever I am having a will executed, I try to encourage them not to have any interested person to sign off on the will. Now, that's not to say that you cannot have an interested person be a witness, but for me in my practice, that's what I choose to do, because it minimizes the risk of something being challenged, so to speak. Because if a person has an interest in a will and they sign, they're a witness, it could look kind of suspect to someone who may not have an interest in the will. So you want to try to minimize as much exposure as possible.
I know. And from my realm as a healthcare provider, there are certain things that as the healthcare provider, the nurses, that we can't even witness, like living wills. We can, of course, do consents for surgeries, but we can't be witnesses on living wills. I believe only the social workers in the hospital setting is allowed to do that, which makes sense, because especially if we tend to benefit from whatever it is. I don't know if I watch too many Lifetime movies, but, usually when folks are, beneficiaries of a large, they end up getting rid of that person sooner than later, because if you're going to leave me millions, why wait? So
that's something to think about.
Can a person change their will even after it's signed?
When you say change in what way?
If I've already signed my will and I guess it files or wherever it goes after that, and I decided, I don't want to do that anymore. I want to change something in the will. Can I still do that?
You can always change your will.
So
However,
it would be amended?
However, you can change it, but not on that document. If you want to make any changes or corrections to your will after it has already been executed, you are going to need to either do an amendment, also known as a codicil, which would have to be executed pretty much in the same fashion as a will, or just do another will. Because if you have a will, at the top part of the document, it actually states that you revoke any and all other will. You revoke a prior will that you may have had done before. So you can make a change, but you just cannot make a change on that actual document. Any changes will basically make the will null and void, and you would end up, if you do make it, it would open up a whole lot of worms and so forth, and that would be a problem.
I see.
And as you update, like some folks update their wills on a regular.
You should update them anytime there's a drastic change. Let's say you had a will, you weren't married, then you got married. Okay, you got a new will. Then you got divorced. Definitely. Please go get a new will done.
So who is... So then you would leave it with the attorney, a copy with the attorney because how do we know, let's say you've changed your will 10 times. How do we know the one we're looking at is the latest one?
The date?
The date? The date. I mean,
but I don't know if you're one of those who do it frequently. Let's say you did it in 2016, or one attorney has the 2016, and then you did one in 2017
with another attorney.
How will we know?
Well, that's a good question.
Sure is.
Wouldn't the newer will supersede the old?
What if you don't know?
She's saying is if you don't know that
there's
person did an
new one,
will, if they updated their will.
Maybe I do watch too much Lifetime, because there was a movie recently. Where I love, Lifetime is based on true life,
story.
Right?
Yeah.
So I learned a lot.
What did you learn? Share.
Okay, so
share.
And this lovely Lifetime movie, so there was an updated will, and that's exactly what happened. They didn't know they were going by an old one, and the new one took out some folks.
Well, see, that's why it's important when you do these things to let someone know what's actually going on, because it's possible, I presume, that you can have a will that was executed in 2016, and then you do another one in 2017, and then you do another one in 2018. I mean, I'm not suggesting that you get them updated that often, but of course it depends on your circumstances and your situation. So everyone's is completely different, but you should let someone close to you that you trust know, hey, I'm going to update my will, and the newest will is here. They should be kept in a very safe and secure location. Some people suggest the lock boxes at the bank. However, if you put your will in a lock box at the bank, then you're going to have to go to the courts to get permission to open up the lock box at the bank, unless the person who placed the will in the lock box at the bank is joint with someone who's on the lockbox at the bank.
This is so complicated. Put it under your mattress.
You can always leave a copy with, I mean, you should not make multiple copies of it anyway. I mean, let's just be honest, because you don't want
everybody to know.
No, just you have your original will in a very safe, secure place, and you can have, I've provided my clients with one copy, and that's typically for the actual person I drafted the will for. But they share their information with whomever they may have chosen to serve as personal representative in the event something happens. But that original document, which is untampered with, no staples should be removed, no crossouts. The state is very funny about those documents because, unfortunately, there's so much fraud and craziness going on now. So you have to be very particular and careful about what it is that you that you have. I actually have a colleague in Palm Beach County, and she refuses to come down to Miami-Dade to do anything at all because she says the process in Miami-Dade is very stressful. And, as I explained to her, I can't comment because this is all that I know. So it may be stressful to you, but it's not stressful to me. But she has also griped, and I understand. She's,
you're used to
right.
the
This
madness.
is what I'm used to.
But it does sound complicated.
It's not really if you really know what you're doing. It's complicated if you don't know what you're doing. In Miami-Dade, there are several stamps that would actually go on one of the documents. I believe it's the letters of administration. It is the letters of administration, where you have to open up an estate in a certain period of time. You have to open up a depository. There are several stamps telling you what you need to do. And her comment is, Palm Beach County doesn't have that. So I can't comment one way or another because I don't know what Palm Beach County does. I have never had to do a probate case in Palm Beach County.
So you probably have a much easier, less stressful life in Palm Beach County. But here in lovely Broward County.
Well, I have not had
not too bad, right?
No, I have not. I can't.
This is so interesting. We have a few more questions for you, but we have to go for a break. So Miramarians, you're listening to Committed to Miramar. We'll be right back.
Unilatina International College with a campus in Miramar, Florida, is a boutique college with an applied, cutting-edge holistic education model. Business, tourism, and communication students not only develop their field intellectual skills, but also are empowered to become holistic professionals through yoga, self-empowerment, Tai Chi courses, and more. Sign up to become a holistic professional at unilatina.edu. or call 954-607-4344.
Unilatina International College offers an English as a second language program for international students. UIC's high qualified ESL teachers help students develop and master the English speaking and comprehension skills needed for both work and pleasure. Our ESL program also focuses on cultural adaptation through fun field trips and cultural experiences. Start your journey today at unilatina.edu/ESL or call 954-607-4344.
Committed to Miramar, committed to our community. It's right here in Miramar.
Hello, Miramarians. Welcome back to Committed to Miramar. And we are learning all about wills, a conversation about wills today, an extremely important topic that if you don't have a will, we would recommend that you obtain one. And if you're just turning in, I want to remind you that the topics and information provided are for educational and or informational purposes only. It is not intended to serve as legal advice, and there is no attorney-client relationship. For specific advice regarding your personal experience, you should contact counsel of your choice. So with that being said, we are going to pick up with...
Okay, I'm excited about this because I'm always fascinated by wills. So thank you for being here. And I would like to know, what is probate?
What is probate? That's a good question. What do you think it is? No, I'm just kidding. No, probate is a process wherein if a person passes, the courts actually are the vehicle by which an estate is open, meaning it's a vehicle by which the person's assets will actually be divided among the heirs. If there's a will, then you would need to admit it into court. So the court is the one that oversees the process to make sure everything is being done according to the procedures and the rules here in the state of Florida.
Okay, so if you have a will, is a probate still required?
Well, it depends. As I stated earlier, there are certain things that can pass outside of your will. For example, a life insurance policy. As long as you designate a person where it says beneficiary, that can pass outside of probate. You would need to go to probate court for that. So
is that an easy process going through probate court?
I don't recommend it, but you have to do it.
You don't have an option.
It can drag out.
If it's a lot of money, it might be worth it. But if it's not,
I was actually on a probate case from 2009 until I think 2015.
That's insane.
It's about 6 years.
Wow.
Well,
there was no money in the estate.
Really?
Oh.
All those years?
And one judge in particular said to me, this is ridiculous. But sometimes that's the nature of the beast.
For what purpose would it drag out for so long?
You can't find all of the beneficiaries of an estate. You have to do your due diligence. You have to show the court that you've tried to find them. You have to do everything that you can possibly do before they will even act. And then it is very expensive. And sometimes, the fact that it's expensive, that's not necessarily good enough. And then there are some instances where the court will appoint an attorney ad litem to make sure that you're doing your due diligence. They have to be paid. Other times it could be held up because, let's say, for example, there's real property involved. It may be 10 heirs or 10 beneficiaries to an estate. There's a house.
Everybody wants a piece of the pie.
The house is, let's say there's a house, and the house, is going to be sold for, you have an offer for $200,000. However, one of the heirs is not willing to agree for it to be sold for $200,000. They want it sold for $300,000. So you wait. You wait 1 month, 2, 3, 4, 5, 6, 7, 8, 9, 10 months, a year. Then the housing market crashes. And then what was worth $200,000 is now worth $25,000. I'm exaggerating a little bit, but just to give you an idea, these are some of the things that can hold up an estate from being closed.
I see.
So there are many different things that one, has to experience. And I will say, and I'm saying this, a lot of people, I don't say a lot of people, but some people believe that, attorneys are paid too much money, and they're making this, that,
law school's expensive.
Well, not only is law school expensive, but there's a lot of time and effort that's put into trying to represent each and every person. And most attorneys try to do a very good job. They try to be diligent and dutiful in what they do. So, if someone shows you the amount of time that they put into a case, I would say try to be receptive, because it's a lot of hard work. It's not as easy as one may think.
I can imagine. In reference to the will itself, getting a copy of it, who is entitled to receive a copy of a will?
Well, typically those individuals who are going to receive something from the will, a beneficiary and heir, you can the most simplistic way to get to see what's in it is to ask the personal representative, can I see what the will said? Can I see? I can't tell you if they'll share with you or not, but you could ask. If you're not named in a will, you may have to, go to court and
probate in order to see
what's going on. I mean, but do know that probate files are pretty much confidential unless you are an attorney of record or an interested party. You cannot pull up the documents. So you just can't say, this person died with $10 million. I'm going to go see who got the money. No,
you can't do that.
You can't do that. They will not give you access. I, being an attorney, cannot go and pull up a probate, an estate from someone that I was not attorney of record for. I can't do it either. So it's not, at least if you can do it, I'm not aware of it. But I know that there was a case where I needed to, someone wanted to retain me to work on a probate case that was still ongoing. But before I commit, I needed to see what was going on. I did not have access to get the records because I was not the attorney of record. So it was.
That's interesting. So similar to healthcare, if it's not your patient, it's not your business.
Right.
But so in this case, if I am a beneficiary, I should be,
you should be
able to get a copy.
But, I would say try to do everything family-like and see if they can share with you. It may happen, it may not happen. Try to be family-like.
Right, be courteous.
Be nice.
It depends on how much money's involved.
Ask Sally Sue, can you get a copy of the document?
But sometimes, we joke about the money, but sometimes folks want something that, is not necessarily, monetary, where it could have been great grandma's ring or something that they have a memory with, or it's not always money. It could be a fur coat. It could be a coat. It could be something, some childhood memory. So even those, if the person that's, in control of it says, no, you can't have it, then you would have to go to court, I would imagine, right?
What if there's an asset that you were not
that was not left to you, but you want it? It's up to whoever was named in the will to receive it, right? No matter what it is.
If you were not named in the will to receive that, then you likely will not receive that.
What are some of the assets that can pass outside of a will?
Life insurance can pass outside of a will. You can also have different types of accounts, checking, savings, depending on how they're titled at the banking institution. So those are a couple. In some instances, the pension account may be able to pass outside of a will, because these are items wherein you would go to the banking institution, or you'd have documents to complete for your life insurance policy. They specifically ask you to state who you want to receive, how much, what is the percentage that you want them to receive. So these items typically pass outside of the probate process.
The pension, I know for sure, because I remember years ago, a lot of our first responders found that it wasn't automatic with the pension going to their spouse if God forbid something happened. And I think that is something that is extremely important that they should know, the moment they sign on, or somebody should be educating them about how their pensions are set in case something does happen to them. So even my husband and I, we had to sit and make sure, from what I understood, if we didn't, catch this years ago, if God forbid something happened to him, I wouldn't have, gotten his pension so that I could take care of the children,
who gets it then?
It wasn't me, that much I remember. I'm like, wait a minute, back it up, come again? It was one of those conversations, and I'm like, what? You know how you do a Scooby-Doo, like, come again? I'm like, but we didn't know. And you see, it's good to be educated. It's good to know and ask questions, especially if something this important. You don't want to find this out, and with a situation like this happening. That's scary, though, because a lot of people don't know.
No, they don't know. But, sometimes it's important. It's very important to know, because it could cost you in the end.
Right. And that's sad. Those who are in charge should really make an effort
yes,
to educate, because once you know and then you don't make the right decision, then that's it. But who wouldn't make this decision? That's crazy.
And this is one of the reasons why, we try to do different legal seminars and workshops and events to educate people. Sometimes people feel, I can't afford to get a will. They are costly. Well, they can be. It depends on what you have and how many people and how much and so forth. So they can be, but they don't necessarily have to be. Each person's situation is totally different. So this is one of the things that we do for community service, to try to give back, to help our community have one of the items that you're going to need, because everyone has to cross over at some point. I don't want to necessarily cross over. I want to be here for the rapture, but I was told that's not really good. But I'm just saying. So, you there are certain things that you want to have in place to protect you.
I agree. And before we go on a break, I want to remind everyone about a nice charity and the save the date for the family law seminar. That's on February 23rd. And the contact information for that is 954-228-9415. You're listening to Committed to Miramar. I'm Commissioner Darlene Riggs, and we'll be right back.
Uni Latina International College offers an English as a second language program for international students. UIC's high qualified ESL teachers help students develop and master the English speaking and comprehension skills needed for both work and pleasure. Our ESL program also focuses on cultural adaptation through fun field trips and cultural experiences. Start your journey today at unilatina.edu/ESL or call 954-607-4344.
Committed to Miramar, committed to our community. It's right here in Miramar. Committed to Miramar. Live, work, and play. It's right here in Miramar. Committed to Miramar is a weekly radio talk show hosted by Commissioner Darlene Riggs and longtime Miramarian Sherry Apton. The purpose of Committed to Miramar is to keep you in tune with what's happening in the beautiful city of Miramar, covering topics from healthcare, entertainment, employment, to education, politics, and much more. Tune in every Wednesday at 5 p.m. to Radio Latina USA. Use hashtag Committed to Miramar.
Miramarians, welcome back to Committed to Miramar. I'm Commissioner Darlene Riggs, and if you're just tuning in, we are here with Miss Latrice K. McPhee, who is giving us some advice. I'm going to read my legal disclaimer. Okay, the topics and information provided are for educational and or informational purposes only. It is not intended to serve as legal advice, and there is no attorney-client relationship. But with that being said, we're having a lovely, lovely conversation about wills. We're learning quite a bit, and we just have a couple more questions for you.
Yes, and I remember it's a matter of family law.
Yes.
Okay, so does a will change name beneficiary for a life insurance policy or pensions?
No.
That one's simple. Okay. It's not more complicated than that?
No. Because remember, a will is okay. Let me try to put it to you this way. The documents that you sign for the life insurance company is for the life insurance company. The life insurance company is the one that has your money or money that one
they're going to disperse.
So that is what they go by. Whomever it is that you choose to allow to receive some of those proceeds,
it's up to you.
Exactly. Now, if there is not one named, then those funds will actually be a part of your estate. So you can't use your will to supersede what you've already indicated on a document that's binding for that entity.
I see.
So no, you can't.
I see.
Now, if it's changed, I don't know, but I doubt that. I just want, I don't know everything. I just know enough. But I just want to, no, but seriously, no, it's
that's why you need that personal representative. So talk to us about that.
Okay. A personal representative is the person that you choose who is going to actually administer your estate. I'd like to suggest that a person spend a lot of time in thinking of who it is that would actually be able to fulfill their wishes. Someone trustworthy, someone who is dependable. Typically, these are the people that I would suggest be your personal representative. Personal representatives are compensated. I don't know if people knew that, but they're compensated.
What happens if they don't?
Of the estate.
What happens if they don't follow your instructions?
The list.
Is that illegal?
Well, if the other beneficiaries get together and they find out, then they can perhaps be removed. I mean, the law does make some provisions for that to happen, but of course, there's a certain criteria and so forth that you would need to follow in order for that to happen. But if they're not doing what they're supposed to be doing, that they swore to do, then they can be removed. For example, if the will, one of the responsibilities, just for example, for the personal representative is for them to pay bills or to provide information about the creditors that they may know of and so forth. If they're not doing what they have been tasked to do, then they are breaching their duty in terms of what their responsibility happens to be for the estate.
Can they decline?
Yes, a person can decline. And that's why typically when you do a will, I like to suggest that you have an alternate because in the event one person can't serve, then this person, and that could be for any reason. They may not want to do it at that time.
Yeah, some folks may look and see there's nothing in it for them and say, no, thank you.
I don't want to do it. Let somebody else
You didn't leave me anything.
Exactly.
You cheap.
So no, I'm not going to do it. There's, nothing there. But yes, a person can decline even if they have knowledge that they are the personal representative that's been chosen by that individual.
And then the court can in turn assign others.
No, the second person, if you have a will, the second person will then step up. And of course, there are some waivers that will go along with that. But if there is no will, then you would definitely have to, let the court intervene and file requisite motions and pleadings, and the court would intervene. And then you have to show that why that person is not doing what he or she is supposed to be doing in terms of what is required for that particular estate.
And of course, a topic that keeps coming to my mind is because I'm sure a lot of folks argue, well, this person wasn't mentally competent, when they put this together. That is something that is required at the time where you're signing for you to be mentally.
Well, that's a problem if they're not.
So that kind of argument would never surpass, right? Because, in order for you to have the will, you need to be mentally.
You are supposed to be. For me, when I am speaking to my clients and I am executing the document, I just ask some questions because I need to make sure you have the requisite capacity. Some states require that you have it for that moment. Other states require that you, different things for different people. But here, the last will and testament states that you are of sound mind, and that's important that you have knowledge of what it is that you have, that you know what you're signing, and that you understand the implications of what it is that you're signing. So it's very important to be sane.
And that's a valid question, because sometimes folks end up, with dementia, Alzheimer's as they get older. But when they set the will together, they could not have been diagnosed with, I remember a case, might have been another Lifetime movie.
Where do you find the time?
Lifetime in Walmart. Walmart, Hallmark. I spent too much time at Walmart this weekend.
4 o'clock in the morning.
No, I avoided Black Friday. I'm sure most of you, there are some stores I was like, okay, no, I'm not going anywhere near that.
Not Black Friday.
Cyber Monday.
No,
but
Monday
back to Lifetime. So there are some and those were true stories, and they don't come out of thin air, where again the person put the will together, they were of sound mind, but then some family members were claiming that this was done post a diagnosed psychiatric disorders. And
let me just give you a situation. It wasn't a will, it was a legal document, and I experienced this not too long ago. Someone contacted my office, said that they wanted a relative to execute a document. I need to speak to the relative. I drafted the document, but when that person came in and I needed to assess if they had the requisite mental capacity to do so, I made the decision that I couldn't do it because they were not cognizant of what it was that they were signing. So it was right before me. So now while the person was mad and upset, that was okay. That's nice. Be mad, be glad. It's not happening because I have to make sure that they understand what they are signing.
So you reminded me of a situation I had many, many years ago. I was director of a home health agency, and I went to the home to do an assessment, and the woman was not mentally together. And part of some of the paperwork that was provided to us was, legal document of a surrogate. And I was like, well, when were these put together? And when was she diagnosed with that? And it turned out that, some of those were put together post the psychiatric diagnosis. So
that will pose a problem.
That's exactly. So I had an issue with that. And
there are some unscrupulous people in the world, unfortunately. And in this profession, your profession, and many other professions, you just have to keep your eyes out and pay attention to those things that are suspect, because you don't want to put yourself in a situation where you are called on the carpet. I'm not doing it. You could misspell your name 10 times. Okay, I don't think this is going to happen today. I'm sorry.
One last question before then you have a question?
Well, no, really, I had a short story. I took your 100 wills the last time.
Did you like it?
I loved it. There's something that was mentioned that stuck in my mind. We're a family of 3 girls, myself, my daughter, my mom. So of course we left everything to each other. But we often travel in the same car. And what I learned from your seminar is that should something have happened, that the coroner decides who is the last person that passed away, and then that person's will kicks in. Something
That's
I
interesting.
never even thought of.
I believe that corresponds to the simultaneous death clause. But that's for married couples pretty much. But I know what you're saying,
That's interesting. So then we have to say God forbid when we talk about these things.
Yes,
so,
absolutely. God forbid, God forbid.
So so it wouldn't matter what your will is if you're not the last person to pass away. To whoever the last person is, their will kicks in. So then, oh my, that
Well, I have to
complicates
get better
things.
understanding. I don't want to comment yes or no because I'm trying to.
You're
understand.
talking 3 generations. So
Correct,
if you all
because
have a
I
will,
left everything to my daughter,
okay,
and my mom, who's in the car. That's our whole family right there. I'm thinking
your family parallels my family. I mean, my mom, my daughter, and myself, just us 3.
Yes,
and I've had family members to say, even we could be going to the exact same location. We all need to drive 3 different cars. Are you kidding me?
Yes.
Driving 3 different cars? That's ridiculous.
So it just
that's very interesting.
I said to my daughter, I've got to look over mom's will. All our stuff could be going to whoever she gave it to.
Oh my goodness, that's true. You see? Oh wow. Okay, poor mom. Go take a look at that will. She's gonna be like, "What are you doing?" One last question: disinheritance. Oh my goodness, am I really out of time? Okay, Miramarians, I want to remind you.
You'll invite us.
Yes, you will. So first of all, thank you so much for being uncommitted to Miramar. You rock.
Thank you.
Just a quick reminder about our tree lighting, that we have 2 tree lightings, one on December 6th and one on December 7th, both at 7 p.m. I believe.
Yes.
Fairway and of course Civic Center. Oh my goodness, time flew by. I'm Commissioner Darlene Riggs. Miramarians, thank you so much for listening to Committed to Miramar.
Committed to Miramar. Live, work, and play. It's right here in Miramar.